And then, the meeting will come to order. I'd like to do a roll call of the members here of the advisory board. If we could start to my left, if you'll say your name, and that would be great.
Antonio Grassi, Houston, Texas, Police Department.
Karen Vasquez, McKinney, Texas, massage therapist.
Russell Russ, school rep, Dallas.
David Lauderstein, chair of the advisory board, and with Lauderstein Conway Massage School.
Paul Stone, Stone School of Massage, Tyler, Texas, a massage therapy establishment representative.
Caroline Guerin, Spring, Texas. I own Laurel School of Massage, but I'm here representing the establishments.
Susan Sparks, Corpus Christi, Texas, and I'm a massage therapist.
All right, welcome. We do have a quorum present, so we can formally call the meeting to order. And we have in front of us the summary of the last advisory board meeting. Do we have any comments or questions or suggestions with respect to these minutes? Asking once, asking twice. Any other comments?
I make a motion to accept the minutes. Russell
Thank-
Rust.
Thank you. I have a
I'll second that. I'll
Caroline,
second.
your name?
Caroline Guerin.
Thank you. Okay, we'll consider the minutes as, is given to us as accepted. Do we take a vote? All those in favor of accepting the minutes as we've received them?
Aye.
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 Any opposed? The ayes have it. And I'm going to pass around, I guess I have this, okay, great. So we have, as you all are aware from with the agenda, a time for public comment. And I've received 2 forms of people wanting to make public comment. And so I'd just like to call up these folks and look forward to hearing from you. So first of all, I have as Nicole Kosich to speak. Would you come up, please?
Good morning.
Hi.
Can you hear me? Does it
Yes.
matter? Okay. Sorry, everything's kind of blurry right now. I'm having some low blood pressure, so I'm glad you called me first. I'm just here because I would like to have representation of
Ms.
independent
Gossage?
therapists.
Can you state your name?
Oh, I'm sorry. I'm Nicole Kosich. I'm just interested in finding out more about waivers. I know that the administrative board will have the power from all the laws that I've read. I've learned a lot, thank you. In order to write waivers where there's been mistakes made or things overlooked in the interest of the public or people that want to start something and see if they want to do it or if they want it to grow, such as independent instructors licensing that kind of got sort of struck out of there and lost in the mix, but saved money on licensing fees. But the rules sort of omitted all those rights and that we originally had. And so things like waivers and stuff, I've been looking for a process, and I've been waiting months. I've turned down $25,000. I have, which puts me and my son in a bad position. I've been trying to work at certain things that I can't get off the ground without such rights and without a waiver stating so. So I'm interested in finding out, how do I get that on a meeting agenda? What do I need to do? And who do I talk to if there's already a process in place? Because usually administrative rules are going to have that, to go back and say, oh yeah, in 95 she had this right. Okay, let's look at that. She's not trying to teach something she doesn't know. All right, so that's all I'm here for.
Mm-hmm. Okay, great.
Thank you.
Any comments, questions? Can questions? Any questions?
Asking a clarification.
Is there, Mary Winston, TDLR, do you have a clarifying question? That's fine.
Does anyone have a clarifying question? No. So, thanks so much.
Thank you.
Okay, great. And I have here a gentleman named Alex Matthews.
Good afternoon. My name is Alex Matthews. I'm a licensed massage therapist, establishment owner, and a CE provider for massage therapy. And I have a question, or it does seem as more of a question, related to massage therapy and TDLR as a whole. Due to recent activities and arrests for massage therapists, such as recently happened in Georgetown, College Station, Temple, and Houston, It seems the state is reactive, so when somebody gets a charge against them, if it shows up in the next background check, if they run a background check, it tends to show up and they'll revoke the license or not submit to a new license. It seems to me with the new addition of massage therapy and some other boards that have come on through healthcare, that the state needs to look, or TDLR needs to look at a way of being proactive. So when somebody is arrested or charged, the information is brought down to TDL, to the licensing division, so they can compare those licenses or those names to licenses that are already on the roster and have them revoked due to charges that have been filed against the massage therapist. An example would be one of the people that was arrested in the recent arrest had been charged with prostitution in Georgetown. It had not completely gone through the court. She was able to renew her license. She was arrested and currently has another establishment license in another city. So all of these charges, the state seems to be proactive or reactive instead of proactively sitting down and working with the police departments and figuring out, if this person's been charged, yes, they have a massage therapy license, and oh, by the way, they have establishment license in these other divisions in other regions. It also seems it would help the police departments if they're working a sting operation or collecting information on an establishment and an inspector goes in and inspects it. It seems to me they wouldn't want the TDLR to shut that establishment down while they're in the middle of their investigations and trying to get the charges ready to set them up for state court hearings.
Very good. Any clarifying questions? Thank you very much, sir. Okay. Those are the two public comments forms that had been submitted, so thanks very much. And we'd like to move on to Section E, staff reports, and I'll have them come up.
Good afternoon, Chairman Lauterstein and the board members. I am your new licensing manager that will be taking care of the massage therapists, instructors, and establishments. I have been with TDLR for 14 years, and it's been a pleasure. So before you have your statistics report. I also want to let you know that we have also updated the renewal form for the establishments, and that renewal application has been posted online.
Your name again?
Chloe Whalen.
Oh, yeah, great. Thank you.
We continue to look at processes that we have that we can update and change and revise to make things better for the community and for our staff as well. So if you have any other questions for me, that will conclude my report.
Russell Rust, I have one question.
Yes, sir.
Can you give me a timetable on when a student can expect to get a license in once they submitted their application? Is there a good time reference for that?
Really depends on if they've submitted all of their documentation.
Right.
So if they submit their application, they submit their transcript, their exam, and we have all of that at one time, we can get that process once we receive the application, and it usually takes about a day.
Okay, how, do y'all notify them if they are missing any kind of
Yes, sir. We
documentation
send
right
them a
away?
letter.
Okay, just want to make sure, because,
We'll send them a letter, we'll make a phone call, we make contact with that individual to get that documentation.
okay, thank you.
Thank you. Any other questions? All right, accepted. Thanks so much.
You're welcome.
Okay. And number 2 is the Customer Service Division.
Good afternoon, Commissioner, board members. My name is Misty Maldonado de Leon. I am filling in for Tuan Nguyen. He is the program manager in customer service for this program. However, he's unavailable today. As you can see, the report in front of you, it's very short. We have seen a reduction in emails and phone calls for this program. And we can only assume that as we better educate our customers that call in and give them more tools and resources for effortless experience with, in customer service for renewals, that it's going to be a trend seeing the reduction in emails and phone calls.
Would you like more emails and phone calls?
No, sir.
Okay.
Thank you.
I don't know that anybody does these days.
We're always improving processes and trying to make it easier for them.
Good job. Thank you. Any clarifying questions? All right. Thank you very much.
Thank you.
Education and Examinations Division.
Good afternoon, Chairman, board members. My name is Lorraine Srofe, and I'm with the Education and Examination Division. You should have your statistics for the jurisprudence exam in front of you. I did want to share that the Education Workgroup did meet on June 26th, and we are in the process of reviewing Subchapter F. We were able to share and advise on some possible changes to the rules to simplify the language and to evaluate some of the current requirements for schools as we move forward to see if those are truly necessary. And as you know, Chairman, we are in the process of still evaluating those items. I don't have anything else to report for you this afternoon, but I'd be happy to answer any questions that you may have.
Any clarifying questions? Okay. Thank you. Thanks for your
you.
work. Number 4 is the Enforcement Division.
Chairman, board members. I'm Chris Vanderberg, prosecutor with the Enforcement Division, presenting our report today. At the last board meeting, I promised, or less charitably threatened, to use these next several meetings to discuss separate components of the enforcement process and then try to weave the whole thing together at the end. But at the speed that these reports are going, I'm not going to gum up the works totally. So instead of presenting that explanation, I'll just present our report. For statistics, as you can see, massage is, I believe, our largest licensee class, and as you can tell by the total penalties assessed, one of our more responsive in terms of actually paying the settlement negotiations that we levy against them. But I think the focus of the board is justifiably in the enforcement of regulatory actions within your profession. And to talk about that, we have to talk about cases. On an unrelated note, this may be a good time to check your phones, but cases are opened when violations of the rules and laws are alleged. The investigatory or inspection report is presented to prosecution, and they're resolved in one of 5 ways generally. dismissal with a warning, negotiated settlement, litigation, or by force of law, by action of law. So these cases, these 5 cases that are included in our report are representative of the methods of resolution. The first case helps illustrate what I think is one of enforcement's priorities, and something I always emphasize at these advisory board meetings. We are not, our goal is not to punish. We do not have punitive criminal powers. Instead, our focus is on bringing respondents into compliance and helping them maintain compliance if that is an option to us. As you can see from the first case, 1026226, this was a negotiated settlement. The initial penalty was $3,000 instead of the respondent accepted liability, began the process of becoming licensure. That's good enough for us. Now we have a promise from him to not sin again. If he breaches that, we can go after him harder, but would rather have a functional member of the functional licensee rather than a default judgment in an empty pocket. Now, on the second case, this is again a variation on the negotiated settlement that I was discussing, but typically what we've been seeing in our inspections and investigations is we'll show up and no one will be doing anything. So it's kind of difficult to establish whether actual unlicensed activity was occurring, but fortunately the laws and rules allow us to pursue unlicensed in establishments that are advertising themselves with specific languages as if they were practicing, as if they were unlicensed establishments practicing massage therapy. And then that's the second case. So we couldn't find actual activity, so instead we went after the advertisements. And you said, as you can see, we still got one, we settled, but for $1,750. Now we turn to the last three cases, and full disclosure, I do not work the criminal history cases, which all three of these. So if I stray from the reservation, please excuse me. But what you'll be seeing in these cases is, for the first, lifetime revocation for pleading guilty to the offense of sexual assault. Pretty standard. Though the 6049 is slightly different in that this sexual offense the actual conviction was invasive visual recording. This is actually a sexual offense as well, and so thereby the license is revoked and lifetime ban. And then on the third case, this is just an example of a different type of revocation. Here, the respondent was convicted of aggravated assault, which is a second-degree felony. Not a sexual offense, but nonetheless mandates their revocation for the duration of their prison stay. Once she gets back out, she can try to get in. But otherwise, I'm happy to answer any questions you might have. But that concludes my report.
Russell Rust.
Sure.
I filed a complaint on a business that's operating out of South Texas. They have now expanded to San Antonio and Houston. They have over 13 locations. And as of today, on y'all's website, only 6 of them have a massage establishment license. What is the due process, or how long? If I filed the complaint, I want to say going on 3 months now. The inspector got back with me, told me the situation for a particular location, yet there's another location in the same area, still does not have an establishment license. You said that you cannot, when you go into these places, if they're not performing the actions, well, isn't performing the action to a degree having advertisement, storefront? I say that they have Yelp reviews, but there is 13. And to just be honest with you, I know there's not a whole lot you can do, but this organization just got a school license as well. Or we just issued a school license last week for a one down in the valley.
And I'd like to answer your question as fully as I can. There's some of the aspects of this are probably out beyond my pay grade, so I don't want to offend anyone. But what I believe what you're talking about, the unlicensed activities, as you mentioned, pursuing them for when we show up and no one's doing anything. As you can see in the second case, we actually did pursue that same allegation with using the advertisement laws and rules. But as for the turnaround from date of complaint through investigation or inspection to actual resolution, it would be unwise for me to make a comment about that because each case is individual. Right now, I believe if you'll take a look at the statistics, of the 765 cases we've opened since May, 228 has been resolved. We have 3 attorneys working these cases, and frankly speaking, this licensee class is generating complaints at a very accelerated pace, and so we're trying our best to keep up with that. But I know that doesn't answer your question.
Okay, but to not bog you down with paperwork,
right.
Am I filing another complaint because they still have not
Mary
done the
Winston,
paperwork to get their
TDLR.
establishment license?
Mr. Rust, I appreciate your filing complaints, but I'm with Chris, and I do want to get you a more complete answer. And I don't know that he can give it to you just on the spot right here, but this is, as a complainant, you are seeking information concerning a complaint that you file. We'll be more than happy. I don't personally have that information, but we will get it for you.
Okay.
Because we're all here. But we'll do that for you personally, and we'll do that for any complainant that calls and wonders. Can't tell you specifically. I know that some of these complaints are very serious, and what you're talking about is very serious. But you want your specific information, and I want to get it for you.
Yes and no, and this is more about assisting y'all as well. And I'm not trying to be too forward wanting the information. I just don't want to bog y'all down
Oh, no,
with
sir.
any continual
You just
complaints
want
about the
a
facilities
status.
or whatever. Okay.
So we're going to get you that status, so you'll know where we are. And for some reason, if someone needs to contact you and they have not, we'll try to get that done as soon as possible.
Okay.
Which is probably today, honestly.
And I was contacted right away with one of the, I mean, she was very forthright, telling me what had transpired, and which was great. And then I'm looking back at the other 13 locations. So
Okay,
that was just
yeah.
me. Okay,
Well,
thank you.
we'll get that for you because we want to make sure, Texas is a very large state.
Yes, ma'am.
That we are connecting those dots, and I'm not saying that we are not, but we're going to check it and make sure that we are. And with your assistance, we'll do that. May
Thank
not
you.
require additional paperwork, but let's have a conversation
Thank
so we
you.
can move that along.
And just for my perspective, please do not, but please file complaints. That's our lifeblood. That's how we find out what is going on within the licensees that we regulate. I'd rather have more complaints than less. I say that now. I'm not a sense of doom,
How about emails and phone calls?
I opened the floodgates. I don't know, I did not answer your question, but hopefully we can get you
That's
a better
okay. Thank
answer. Did anyone else have any questions?
Antonio Gracia.
Yeah.
I got a question. Are there any lifetime bans, like Mr. Moore here, if he gets convicted of this, is anybody else other than Mr. Moore, do they get kind of banned for life for applying?
Back up.
Cavalry.
I'm Ron Foster. I'm a senior prosecutor. So I don't know specifically all of the circumstances under which a person can get a lifetime ban, but there are circumstances where that can happen. I don't know what the total numbers of that are either. That would have to be a statistic that we went and acquired.
Okay,
Thank you.
We could provide that number if
We
we
can do
needed
that.
to. I believe.
great.
Mhm.
What, do we have it on here?
Excuse me, but would that not be what the work group worked on to get those aspects of the criminal convictions? What would be
That'd be part
considered-
of it. See, the statute provides for some persons to be barred from obtaining a license in certain circumstances. That's not something that would necessarily have to be part of the criminal conviction guidelines.
Okay.
Mm.
And I'm sorry, I'm not finding it exactly what you're looking for on this statistics right here.
Yes, thank you very much.
Thank you very much. I also have another question.
Paul Stone has a question.
I don't think that
Is there any other questions?
Okay.
Yes.
Yeah,
We
Paul,
have
Sto-
more questions.
Paul Stone, I just had one,
No, go ahead.
I just had one question on the two administrative cases,
Yes?
the first two. Is there any, these people are more likely than most licensed massage therapists, even though it's not a criminal conviction, to become recidivist. Is there any reason why does it betray some element to list the city and maybe even the address, the location where these infractions take place?
No, that could be included right here.
I would appreciate that. I would like to, not that I'm going to go boycott or picket, I would like to know where they are, though.
And these agreed orders these agreed orders are public record and available as in the original documentation on our website. So obviously the massage establishment location, the names, all of that would be included. So, but if you would like to have that included in the summaries that we present to you, I'll
Yes.
make sure that that's done in the future.
Thank you.
Thank you.
And in regards to the previous question, I just wanted to make it clear that specific cases that are open right now, we can't answer questions about that. These matters have already been resolved by the Enforcement Division. That's why we're able to talk to you about it right now. So specific open complaints that are open, you would need to contact us individually on those cases if you're involved.
Great. Well, thank you very much.
I have a question.
Oh, go ahead.
My name is Susan Sparks. In regards to the turnover time, it seems like maybe a quarter of the cases were resolved, but obviously some cases take longer, and as Chris was saying, it's going to accelerate. Do you foresee getting more attorneys working on this, so that it just seems like it's taken a long time to move the process?
So actually, I'm not sure what the specific time frame is on any particular case. In regards to resources, we have sufficient resources. We have about 18 attorneys on staff. We have 3 of them on this program. I think we're short a couple. I'm actually in the process of hiring a couple of attorneys right now. That being said, we reallocate our resources as necessary. So if all of a sudden I thought there was a flood of these type of cases coming in and we needed to assign additional resources, we would definitely do that. We have other, as you are well aware, we have other programs that I've had attorneys assigned to as well. But we look at the numbers, the statistics that are coming across for every one of our programs, just like what you see before you here today, and we can reassess that at any time and reallocate our resources. So.
Thank you.
Just to add on to what Ron already said, I think partially the cases opened number may be larger than it would normally be once our process is up and rolling, as there was a backlog of cases from the prior agency, and I think that may be inflating the numbers, though I don't want to speak too far on that.
Antonio Gracia, got a question. Are y'all doing anything type of legislation to attack these foot massage parlors, massage establishments
Okay, that's
in the
a little
future?
bit- That's beyond what Enforcement Division does. We don't, we're not involved in passing legislation or making recommendations on that. Sorry.
Good question. All right. So, thank you very much.
All right.
Appreciate it. Okay. Next would be the Field Inspections Division.
Good afternoon.
Hello.
Hi, my name is Tanya Guthrow. I'm the director of the Field Inspections Division. And our first item is recent accomplishments and current projects. And of course, our big push for this program is to institute the massage therapy establishment inspections, and those are up and running. We'll talk about the numbers for our last item here, but we have inspectors who are trained. We have a reference guide for them to use while they're out doing the inspections. The computer program is up and running, and so we're good to go. We're going to start training some additional inspectors and ramping it up, but we wanted to start out slowly and carefully and make sure that we felt like we knew what we were doing. Our next item is for the massage therapy school inspections. And we recently met with the advisory board work group. We'll talk about that as under a different agenda item. But we went over the reference guide for the massage therapy schools. We have already performed a couple of school inspections, pre-license inspections for schools, and we're ready to start out in the real world doing some school inspections. Again, we'll use the same approach where we start out kind of slowly, make sure we know what we're doing, make sure if we need to make some adjustments to that reference guide that we do that. Also, on May 30th, our inspector in El Paso worked with our strategic response coordinator, Jennifer Harless, and Grace Hernandez, an enforcement investigator, to assist in an on-site inspection and investigation of an illicit massage facility in El Paso. Other agencies present included the Texas Department of Public Safety and El Paso County Attorney's Office. So while our charge is to inspect licensed facilities, every now and then we're going to work with different regulatory authorities to assist them if needed, and just make sure that the program is moving forward and that people are being safe. For the division personnel updates, we have recently hired Sharon Hollins, who is a new inspector in our DFW area. We lost our South Region Manager, Jennifer Harless, to the Strategic Response Coordinator position. But we congratulate her, but we also congratulate our South Region Manager, Fernando Reyes. In addition to that, we recently posted for some field inspection liaison positions, and we've actually completed those interviews, and we hope to make those offers soon. And then consequently, that was an internal posting. We will be posting for a few other inspectors. Those two positions potentially, and then we have some other replacements to do. I'd like to send my regards to one of our inspectors who is leaving us. He's just already, it's time for him to retire and resign. I want to thank Jorge Vega in San Antonio for all of his hard work. And we just have a new position that should come available in September. So potentially 4 additional inspectors are coming our way. I'd say additional replacements and then 1 additional inspector. Also, looking at our field inspections and statistics and trends, you'll see we have our numbers at the time we submitted this through May, showing 11 inspections. But I'd like to add that in June, we actually did 29 inspections that are not shown here because we didn't have that information at the time we completed our report. But I hope and our goal is to continue to increase the number of inspections that we're doing monthly. Any questions at this time?
One question, please.
Yes, sir.
How is the school inspections list come to your department rather than examination and education?
Well, the school inspections are falling under the field inspections division. So we do, and we can talk more about the development of the reference guide when we talk about the work group report. But that probably, I think it was March 1st, there was a change in moving school inspections from under exams and education to the field inspections division. And that's an efficiency issue because they can do not only school inspections but other types of inspections based from where they work out of their home. Yeah.
Okay. Thank you.
Makes sense?
Any other questions?
I think you look like you have a question.
No, just listening.
All right, thank you all.
Thank you very much.
Tanya.
All right. The Regulatory Program Management Division.
Okay, thank you, Mr. Chairman, board members. I am Lee Parham. I'm the Deputy Division Director for Regulatory Program Management. And I'm going to say RPM from now on because that's kind of a long name. We changed our name March 1st from the Compliance Division to RPM. David Gonzalez is our new Division Director. He has many years of leadership and management experience, actually here at TDLR. I've been here since 1997. Actually, well, I'll date myself, but actually I've been in state government, state regulatory government 29 plus years. So we have a lot of experience in this division. Between David and I and all of our staff members are great. So as Tanya mentioned, Jennifer Harless is our new strategic response coordinator. We are finalizing our program and staff realignment efforts, and we did this to better help our customers, whether it be internal, industry, or the general public. Excuse me. Now, effective June 1st, Yvonne Feinleib began her duties as our new building and mechanical section manager. She's back there. Okay,
Hello,
with Yvonne being the new section manager, it's accelerated the massage therapy program transition, which which I will get to a little bit later in this report. The massage therapy program has 2 new staff members, Elizabeth Perez and Marinella LaFleur. Both have been with TDLR since 2005 and bring a wealth of knowledge and experience with them. Currently, Yvonne is working with Elizabeth and Marinella on this transition. Okay, our RPM staff have reviewed and approved changes and updates to the design and the structure of the massage therapy web pages. You can go on the website and check those out. They're interactive and very informative, easy to read and easy to pick out what you need to, what type of information you need. The training and transition plan that I said earlier is underway to complete the transfer from medical and health professions to the business and professionals section. Now, the business and professionals section, the programs in that group report directly to me. An update on our medical and health professions section related to massage therapy. We're continuing to provide the monthly training and discussion with the licensing division as well as the customer service. We put a lot of effort into trying to share industry knowledge, experience across program as well as divisional lines. We try to spread the wealth, make it easier on customer service, the frontline people answering phone calls. The medical and health staff, they've also written and produced 3 quarterly newsletters that spotlight the programs within medical and health section, and massage therapy is in the next one. So you all will be included in the 4th issue. They're working on it right now. So that's my report. If you have any questions.
I have a
Yes,
question.
ma'am.
Karen Vasquez. I'm not sure I understand. What I'm getting from this is that massage therapy is currently a medical and health profession, and you're changing it to a business and professional
Correct.
section?
It's-
I'm sorry, and then you say that we're going to be in the next health monitor, which is for the medical and health professions. So then are we not going to be in that anymore?
I'll clarify that for you.
Okay, thank you.
Thank you.
Okay.
Good question.
Programmatically, the massage therapy will be in the new section. We're still going to be working directly with the medical group. So it's what I was mentioning earlier about across division lines or program lines. We're trying to get the best information out there as we possibly can. And this is an opportunity to add 2 more people or 2 additional people to the massage therapy program, as well as, hopefully still use Yvonne for, for her expertise. Did that clear that up?
So I guess my question is it's not affecting us professionally. It's just something
No.
that's an internal.
No, this is an internal thing.
Okay.
Yeah, no, this.
I was like, well, I consider myself a health professional, so. Okay.
And one
Mary
follow-up to
Winston,
that,
TDLR.
we'd be
Oh, I'm
still,
sorry.
I'm sorry.
Mr. Russ?
We'll still be considered a healthcare practitioner.
Yes.
Yes.
Okay.
Yes, this is just an internal structural type
Oh.
move to kind of move some staff around to help push information better.
Mary Winston, TDLR, and I have to tell you, Lee didn't even want to get up there today because he's more of a director leader. He does not love this. But we kind of shoved him on up to the front. And just the information he's providing are internal changes to better serve you. So Yvonne Feinleib has gotten a promotion. she got a new job. However, part of that, she'll still be serving massage therapy, different programs that she's dealt with before, but we have additional people. So those are internal things that we're just kind of letting you know. You are still the same as you were before. You are medical, you are health. But I'm apologize. I'm sorry, Lee, because I did, shove him on up there.
I actually love this.
I think you're doing a fantastic job.
Any
Keep
more
it up.
questions?
The emails and the phone calls.
Any other questions for clarification's sake?
No, that's good.
Okay.
Great.
Thank you, I appreciate it.
Thank you.
Thank you.
All right. And now, from the executive office,
Yes, Mr. Chairman and Advisory Board members, I'm Nick Boenis, TDLR Chief of Staff. Thank you for being here today. Thank you for your service. And going to bring you a little summary of what's happening around the agency. We just completed our strategic plan, as most of you know. It's something that the legislature mandates all state agencies do every couple of years. And it's something that we take very seriously. We hosted external sessions in cities like Arlington, El Paso, Houston, McAllen, and Austin. Some of you were there, and appreciate your input. But these sessions were an opportunity for everyone to share ideas and opinions on how we're doing and how we can improve. For those who were unable to make one of the sessions in person, we made available our Facebook page and our web page for them to participate through. And we also conducted internal sessions with our staffs throughout the agency. And the final report was completed and submitted to the Office of the Governor and the Legislative Budget Board. And it is available for viewing at tdlr.texas.gov. And for those of you who don't know what it looks like this. And it's front and center on our website to check out. I do want to mention 3 initiatives that would affect the massage therapy program. The first one was to prevent human trafficking and reduce fraud in your profession. There's four parts to that one. One would allow TDLR to use fingerprint background checks to prevent bad actors from other states from having a safe harbor in Texas. Another would require posting of a human trafficking awareness sign in your place of business. And this was actually adopted in one of our other programs in the cosmetology program this year. And those signs are available on our website now if you would like to post one in your business. And it looks like this. And another one looks like this. So you can choose which one you'd like to use if you'd like to use one now. Also, another would allow TDLR to issue student permits, standardized school reporting of student hours, and determine exam eligibility. And this is being done in barber and cosmetology programs and is very successful, and this would prevent folks from gaming the system by falsifying student records. Another would tighten up the definition of massage therapy to close loopholes and to bring it more in line with national standards. The second initiative would improve enforcement for massage therapy. 3 points there. TDLR would like to streamline enforcement provisions and create a standard process for our health programs. This would include the recently transferred programs from DSHS, including massage program and our podiatry program. We also want to remove the 5-year sit-out period for licensees who have a violation of the massage therapy statute. The reason is it applies to even the most minor violations. And the third was to provide TDLR authority to revoke a license for people convicted of sexual offenses. Our third initiative was to remove business burdens for barbers, cosmetologists, and massage therapists. It would allow an establishment to provide massage therapy and other services under one license. The benefit there is to cut costs, make it easier for licensees to reduce the burden, the regulatory burden for those who want to have a business that offers multiple services like cosmetology massage or barbering massage, and there are some that are already out there now. So next up on our schedule is our legislative appropriations report, which we are in the process of producing now. Staff is busy identifying exceptional items and writer requests and providing information on revenue estimates and expenses. Once that is complete, our commission will take it up this Friday at their regular meeting, and the deadline to submit to the governor's office and LBB is July 27th. Also like to update you on our outreach, including your website, and update you on some traffic numbers associated with the programs. Their numbers are pretty good. I want to remind you that, as Lee pointed out, that our website, web staff updated your site recently as part of an overall web content initiative, and the updated version launched 5 months ago. So the site is easier, cleaner, a little easier to manage right now. So over the past 5 months, the massage therapy website had just shy of 200,000 page views, 198,549. That's an average of 1,324 per day. Pretty good. And 51% of those visitors accessed your site from a desktop computer, while 43% did so from a smartphone, and another 6% from a tablet. The top reasons for visiting the site: license search, how to renew an existing massage license, apply or renew online, administrative rules, and frequently asked questions. Also want to remind you that we have a presence on social media with Facebook and Twitter to keep up with this program and other TDLR news and activities. Your group also has a group of about 10,000 subscribers that receive various email blasts from the agency and pertaining to your program. And if anybody is not receiving those that would like to, please just go to the website and you can subscribe to those. So, thank you. If you have any questions, I'll be glad to answer them.
Russell Rust.
Yes, sir.
When you say broaden the definition of massage therapy, what does that actually mean, or what are you looking for there?
Mr. Oh, I'll start. And as Colleen shifts through, when we say broaden, we have the definition that Texas has currently, statutorily. Throughout the different states, there are different definitions. Colleen had a meeting earlier that briefed her on some research about those different definitions. We want to be consistent with the rest of the United States as to what that definition is. So it's some research that we're doing to make sure that we do have that consistency in the definition of what is massage therapy.
Okay, and doing this for 24 years, I have not found a consistency in definitions through any of the states. There may be one or two that have similar ideals, but this is one of those things where I would love to have a straight definition, but unfortunately, I've searched each and every state law in other states in my position as AMTA Chair for Law and Legislation as well, and I've been involved with other states such as Oklahoma in bringing licensing in, and those definitions are really tough with the term anatomy, physiology, all those could be facts. Massage is a subjective subject, and like I said, I would like to have that as well, but trying to get a consensus from all the state laws or different laws that are in place, they're all over the board. So we're going to take a word from this one, this one, this one, and just kind of, but I know it's a tough situation. We've been in the business for a long time trying to define this over the years with the Department of State Health Services as well. So.
And we appreciate each and every one of you, and that's why you're here, because of your expertise and the history you have with the program and how you stand in your individual professions. And TDLR is new at this, and so let us take a stab at it.
Okay.
We are starting way behind where each of you are in various points of view, but we're gonna see what we can do.
And understand, I'm looking at Texas. I'm not really looking at the national level since it's all over the board with educational hours and everything else. I really want to keep this about what Texas is going to do and how we can maybe be in the forefront of how other states look at the regulation, and we have a real good chance, a real good opportunity here for us to set the standards, and we need to really just be concerned about the state of Texas at this point, in my opinion.
Definitely, as the Texas Department of Licensing and Regulation, we do put Texas first, and we do seek to be that model agency to provide these things. We do look at different states, and we do conduct research and do comparisons and contrasts. Doesn't mean that we're going to use it, but it does mean that we get a knowledge base that we don't have because we're not practitioners. That's why we have work groups. That's why we do have our general counsel. We have our different folks in RPM who, some of us in RPM have a lot of experience. Others were relatively new, and some are very new. But this exercise that we're doing is necessary for TDLR.
And I appreciate that, and I like the fresh eye, looking at it from a different perspective instead of the history that we've had and all the, I don't know, stuff that has been built up over the years. I do like that fresh approach, and that's
We
what I'm
really
looking forward
want
to.
to give that. Mr. Chair?
Hi, thank you. Yes. And I have a question. When it comes to these recommended statutory changes, should people see these recommendations, I mean, people will see these recommendations on the website and so on.
Yes, sir.
What shall they do to make their comments or opinions known? What are, for us as well as any therapist, with regard to these changes? Is there commentary invited at this point?
Well, I have to tell you, I don't think I've ever met, you guys are not shy. So I don't know that we've ever had to invite a comment. We welcome them all, but and
So
you
we are
can-
welcome to.
Oh, yes,
then
definitely.
People should know that.
Because I have to tell you also, these weren't done in a vacuum. We went out there to all these different cities. I was in El Paso, McAllen, Austin, we were in Houston, I don't know, we were Arlington, several places. And we invited, and we had some of you there, all of our licensed bodies. And based on that, this time we had a newfangled technology where you could text in and it would pop up on the screen as well as, so it wasn't just relying on the human hand to try to take what you're saying. We took it directly from your phones or computers that you provided, but we offered assistance if that wasn't available to you. These ideas came from those sessions, so they also came from some of the people in the sessions. And I have to tell you, they're just ideas. We don't make the laws. These are bits of information that we gathered from our licensed body. We put them down as closely as we could to relay them, to move them forward as what our licensed body has voiced to us. But that's all we can do. We can't lobby, we can't, so
Yeah.
these ideas were the best ones that we could capture from our strategic planning.
Great.
And where they go, we
shall
are
see.
not sure, but
All right.
yeah.
And one more follow-up.
Thank you
on-
very
I'm
much.
sorry, dude.
Go ahead.
One more follow-up on that, Russ. Whenever we deal in this kind of thing, are these recommendations, there's a large fraction that y'all are concerned with that hold a license, with other fractions out there that seem to be in the same kind of nature of the business. I just don't understand if they were to have opinions and on that, how does that play into TDLR since y'all have no authority over other occupations that may be similar to ours?
I'm not exactly sure I know what you're speaking about.
Well, as David mentioned, can people comment, y'all want to hear from us or whatever? Whenever we go through this, we are the only ones as licensed massage therapists that are directly affected by the laws and the rules that are passed. How do other entities that may be practicing similar occupations at us that are not regulated, where does their say-so or definitive titles come into this if they're not regulated now?
Honestly, for us, information. If they provide us information, We take in that information because all documents that come to us are public information, are discoverable. Anybody can ask for them, so anybody can see them. So we do like open and free communication. We put as much out on the internet as we can. And there are different associations, not necessarily within your profession, that keep an eye on different professions that we regulate. They could not be one of the 800 and plus thousand people that licensees that we currently regulate. But they have another interest, and they keep an eye on you. So sometimes those individuals, associations, or what have you, may provide us information that becomes part of our public record, but it's just information that we take in. We're not swayed by what they bring in. It's just additional information.
Okay, thank you.
Okay. Thanks so much.
Oh, Colleen,
Colleen?
I'll just do 2 comments. One, the way the strategic initiative is written is not necessarily to broaden the definition so much as it to make it clear. So defining those lines, what those lines may be. So, so that we have a better idea of the world in which we are allowed to work and what it looks like. And then the other comment that I make is taking in information from anybody is never harmful for somebody like me who doesn't do the work. I don't know who may be interested and I don't know what it looks like, but it's helpful to me to have that information. Just like when we do our strategic plans, the groups that are grouped together are not all the same. All of our programs are not the same, but you can sit in a room and hear what another profession is looking at, working for, has that maybe your profession doesn't, that may spark a different idea, and building on those ideas and building those for your profession may be helpful. Or something when you hear and you'll say, nope, we don't want that, so don't do that. So just so you know, knowing the world in which to work in is always helpful for me.
All right, thank you.
Thank you. Okay. We could move on to section F here. Discussion and possible action to recommend approval of criminal conviction guidelines for the massage therapy program. Thank you.
Afternoon.
Hi.
I was up here earlier. We played some musical chairs, but I didn't win the cake, so now I'm back again.
Too bad.
My name is Ken Sharp. I'm one of the enforcement prosecutors here at TDLR, and I'm here to present to you the proposed criminal conviction guidelines for the massage therapy occupation that was developed by the Massage Therapy Workgroup back on March the 2nd. The law requires that every agency in the state that issues occupational licenses prepare and publish criminal conviction guidelines like the ones that you have here, similar to that. And these guidelines are supposed to inform the public which criminal convictions can be used to disqualify a person or render a person ineligible to hold an occupational license in the particular occupation for which they're written. Consequently, since the law requires it, TDLR has prepared or is required to develop and publish guidelines for all of our occupations, including the massage therapy profession. So today we're going to talk about the law that applies, our enforcement process, how we use the criminal conviction guidelines, how they benefit the public, and how these criminal conviction guidelines that you have before you were developed. And then we'll also take a look at the proposed guidelines for the massage therapy profession. At the end, it's our goal that you will, or that together we'll have a set of criminal conviction guidelines to submit to the commission with a recommendation for adoption by the commission. That's our goal. I want to start by giving you a quick description of the laws that apply, how we in enforcement use those laws. And I promise I'm not going to read any laws to you or cite any section numbers or anything like that to you, unless you ask. I mean, we won't hide anything from you, except maybe my driving record. The Occupations Code guides the Department of Licensing and Regulation in the regulation of all its programs, including, of course, massage therapy. The two most relevant chapters for this purpose in the Occupations Code are Chapter 455, the massage therapy statutes, and also Chapter 53. Now, Chapter 53 is the general law that pertains to the denial, suspension, or revocation of licenses based on criminal offenses, when there's nothing more specific that applies, that is. Like I said, these are general. Now, the massage therapy statutes in Chapter 455 do have some very specific statutes that apply. There was some discussion about that earlier, and I think we can probably clarify or go into a little more detail if you want to. We're going to talk about as much as you want to on this kind of stuff. We've got Chris Russey over there who knows how to operate the smart board. He knows how to operate computers and other complicated stuff like DVR controllers. So he's going to do that for us, and he's going to bring up some things. The first one there, I think that's, I'm not going to say the section number because I told you I wouldn't. But anyway, that's a very specific provision in the massage therapy statutes that requires license revocation for people who are convicted of, or licensees who are convicted of, or even if they've just pled guilty to things. If that's for me, would you tell them I'm busy? That's okay. Anyway, this requires revocation for people who've been convicted of, or even if they've just pled guilty, or nolo contendere, or things like that, for prostitution, sexual offenses. There's another statute, if we scroll down, that makes a person ineligible for a license when that person has committed offenses like human trafficking or public indecency, and that would encompass prostitution as well, and other sexual offenses. And I'm not sure, but that may have been the one that somebody referred to earlier. Is that the one where a person is just completely ineligible for a license? Mm-hmm. Is it? Okay. And that's a blanket timeless limitation. Once a person is convicted or put on deferred adjudication, or even if pleads guilty and it all goes away later, all bets are off. You just can't have a license, period. Now, they are very specific, and that's good, because there are some things there that are very important to the massage therapy program that should be addressed in the massage therapy statutes. But those statutes do not address things like theft or assault and things like that. Fortunately, Chapter 53 does. It provides authority to address those kind of topics, and it provides quite a bit of authority. It generally authorizes agencies to deny license applications, to revoke or suspend licenses that have already been issued when the department can show that there's been a conviction or a deferred adjudication for a criminal offense. And there's 4 categories here that I'm going to go through. For criminal offense, it's number 1, directly related to the occupation, and we'll talk about that again in a minute because that's what these criminal conviction guidelines are all about. That's the first one, directly related to the occupation. The second is those offenses that were committed within 5 years prior to the application date. So they're not necessarily directly related, but they're recent. The third one, that's a category of really bad crimes like murder and aggravated robbery, aggravated kidnapping, really any felony that involves a deadly weapon also. Then the fourth category involves sexually violent offenses. Those are things, of course, like sexual assault, indecency with a child, compelling prostitution by a child, even burglary for the purpose of committing a sexual assault. That's one of those sexually violent offenses. Excuse me. So those are the 4 general categories in Chapter 53. And for our purpose today, as I said before, that first one, the one that talks about the crimes that are directly related to the occupation, that's the one that we're going to deal with the most. And you might ask, well, okay, if TDLR has Chapter 53 and it talks about these directly related crimes, then why do we need these criminal conviction guidelines that list directly related crimes? Well, there are 2 reasons for that. The first is the law requires it. In Chapter 53 of the Occupations Code, it says you will, state agency, prepare these guidelines, and you will publish them so the whole world can see what they are. The second is that the criminal conviction guidelines that an agency adopts are general in nature. This gives the public a general idea that if you're an electrician and you're an habitual thief, you're not going to be allowed to be an electrician on a general basis. Chapter 53, on the other hand, I mean, sure, it does that too, but it also allows an administrative law judge in a particular case the authority to look at the circumstances of that case, to look at that person's individual circumstances, to look at the crime, and to determine that in that particular instance, that crime was not directly related to the occupation. So, for example, if you have, let's say that you have in the massage therapy guideline, certainly you have them in the proposed guidelines, crimes against property such as theft. Well, suppose you have a licensed massage therapist who on the side is an avid model railroad caboose collector. And this person has one particular rare caboose that this person wants to get and has been trying to buy it for years. And it sounds familiar, doesn't it? No, I wasn't talking about you. I promise.
No. I like boats.
Okay, all right. As long as I'm not treading on your cabooses, I'm just. But this person wants to buy this one particular rare model, and the person who owns it doesn't like him and won't sell it. He's not a collector himself, but he won't sell it. He's just being mean. So the collector, the massage therapist, steals it. He gets caught and he gets convicted. This person, for 20 years, never had any kind of criminal conviction, or never so much as a speeding ticket. And then does this one thing. And then goes to some therapy, and they have programs like Respect, Thinking for Change, and all these kind of fancy things that tells you you can't steal people's stuff, and tells you why. And after you go through these programs, you feel a whole lot better about yourself and about other people's property remaining other people's property. So he shows up to the hearing and he does all of these things, and then the administrative law judge looks at all the circumstances and says, this time I don't think this particular crime is directly related to this occupation. And so I don't think this person should lose this person's license. Chapter 53 gives that authority to the administrative law judge. Now, when the administrative law judge makes a recommendation to the commission, then the commission can decide and make the final decision. But just in that case of that discouraged caboose collector having committed that one theft out of desperation, that may not be the one that, even though it fits under the guidelines, the agency's guidelines, it may not be something that under Chapter 53 the ALJ thinks should be a reason to disqualify the person. So there is that flexibility, if you will, built into Chapter 53. There's another factor that we consider when we look at each application and when we look at each applicant, and that's, it's actually three factors, I guess, but it's lumped into one: honesty, trustworthiness, and integrity. We consider whether a person's criminal history shows whether that person lacks the requisite level of honesty, trustworthiness, and integrity to hold the license issued by TDLR. Would that criminal history suggest that he's going to pose a threat to others or a threat to their property? In addition to the person's criminal history, we also consider how the person filled out an application. A number of times we get applications from people who have a criminal history. We check everybody's background. We do check everybody's. And if it shows up that they have a criminal history, but they've said on their application, no, never been arrested, never been convicted, never been placed on deferred adjudication, none of that stuff, no criminal history. Okay, they just lied to us. So we consider that as part of the overall picture. Sometimes they will say, well, yes, I do have a criminal history, but not reveal the whole thing. Take, for instance, the person who says, well, yeah, I had this possession of marijuana conviction from 15 years ago. And that's all they tell us about. They don't tell us about the aggravated assault conviction that resulted in their imprisonment, for which they were just released last year. So that's another indication of whether they hold that requisite level of honesty, trustworthiness, and integrity. And we look at that. So I think that's a summary of the laws that we look at when we consider a current license application or a renewal application. And are there any questions so far on any of those things? Please feel free to interrupt me. I'm married, so I'm used to it. As I said, I work in the enforcement division. I shouldn't have said that, shouldn't I? I work in the enforcement division. There are two of us attorneys in the enforcement division who do what I do. We are responsible for reviewing the applications for licenses and for the renewals applications, and we review those for the people who have a criminal history. Not all of them, because some people don't have any criminal history. We don't look at those. But if we conclude that a person's criminal history disqualifies the person from holding a license, then we'll notify that person in writing, and we'll also notify them in writing that they have the option to contest our determination in an administrative hearing. Now, the person can elect to accept our decision and just move on, do something else. Or the person can, as I said, they can say, well, I want a hearing. I want somebody else to make this decision, not just you. And so when that happens, we have that administrative hearing before an administrative law judge at the State Office of Administrative Hearings. That's a lot of administratives. That administrative law judge, or ALJ as we call him affectionately, will listen to all of the evidence that we bring, and then all of the evidence that the person brings, and then make a proposal for decision. It's a recommendation that goes to the commission, and the commission makes the final decision. If the commission says, yeah, you shouldn't have a license, and revokes the license or denies an application, the person can still appeal it. I mean, that's not the end of the road. They can appeal it to the Travis County District Court and then on up the chain of appeals if they want to. Or they can just accept that decision and move on. I would add here that even if the person's license is denied or license application is denied or the license is revoked, except for those specific statutes that say it's forever, that person could try again later. We don't just disqualify a person from a license solely because there is a criminal conviction in that person's past. We look at things like how old was the person when the person committed the crime? How many crimes has the person committed? How extensive is the record? How long has it been since the person committed the last crime? So if you've got somebody who shoplifted some bubble gum when they were 19 years old, you know, or maybe stole a DVD at a department store while they were in college, and now they're 40 years old and they're looking for a license, haven't done anything since then, it's probably a safe bet they're not going to do anything else if they've straightened out for that long. So it's not just the fact of a conviction, but it's a lot of circumstances that we consider to determine whether a conviction should disqualify someone from a license. That's a summary of our license review process. Any questions on that?
I have a question. Caroline Guerin. Can they get this information before they even go to school if they have a conviction?
Yes.
Send it
In fact, if they go to enroll in a school and that school is regulated by TDLR, that school is required to advise them that they can ask for a preliminary determination from the department. That's a criminal history evaluation letter that we prepare by looking at their record. We look at the guidelines. We look at any information they submit. They might submit certificates of rehabilitation, like we were talking about a minute ago. They might submit letters of recommendation. They may have any number of things that they'll submit along with their application for that evaluation letter. And when they do, Trevor or I will look at that and we'll make, as best as we possibly can, a preliminary determination as to whether that person is eligible for the license. 90 to 95% of the time, I think we're right, although we're not bound by that. You know, if for example, a person says, well, I want to be a massage therapist. I want to go to school for that, and I want you to write me a letter. And they say, okay, fine. So we do that. We look at the record. It all looks good. We send them the letter and say, yeah, you're eligible. We think you're eligible. And this is great. So the person goes to school, and then he gets out. He gets his first assignment as or maybe still going to school. Let me back up. Still going to school, but while in school, commits an aggravated sexual assault. What does that say? Not eligible for license ever, period. So we're not bound by that letter. We say, no, wait a minute. Circumstances have changed. You don't get the license now. But like I said, 90 to 95% of the time, they go through just like that, and they're okay. And those schools are required to tell those people that they may get one of those criminal history evaluation letters, if they want to, before they spend the money for school. Okay?
Can I ask a question? Yeah, Paul Stone. When you say the schools are required, at what point is the school required to notify a prospective student of the preliminary determination process or whatever? I'm sorry.
One comment, we now have a form that we must sign along with the student that states the criminal conviction portion that they may not be eligible. There is actually a separate form that goes in your enrollment agreement.
It's at the enrollment process.
Okay.
And as I understand it, and I don't know, a really smart couple of ladies right over here can clarify it if I'm wrong, but before they sign the enrollment, to pay up the money, they have to be advised that they can get that criminal history evaluation letter.
Right. We have it on our, we have a form that they sign with a number of things, that they received a handbook and the complaint process and things like that that we're required to inform. But I'm just kind of, as far as, other than that, the signature that they provide about, you know, if you've pled guilty or whatever, however the language is written, additional to that, do we have some responsibility? I'm just not really totally
You
clear.
can't make them ask for a criminal history evaluation letter. All you can do is comply with the law that says you have to advise them that it's possible for them to get one.
Okay.
To advise them that is available to them. That's all that you have to do. Now, whether they get one or not, that's up to them.
Right.
And there are people who, they ask for these letters, and there is no school involved at all. They're maybe going to be a tow truck driver or something like that, and maybe they don't have to have much or any school. I don't know, maybe somebody else would know about that. But some other occupation where there's not really much school involved, maybe mold, a basic mold worker. They can ask for one on their own. They don't have to go to school to do it. It's something that's available to everybody.
What roughly is the, and I know we've had students, prospective students do that before, what roughly is the turnaround in general on getting an answer back from you guys?
Roughly, the turnaround is going to be within 30 days on that one. We have 90 days to do it, but we place a high priority on those because we know people want this for a reason, like to go to school.
Thank you.
Sir.
Any other questions or comments?
Thank you.
All right, thank you, and thanks for the work you're doing. We appreciate it.
Okay, I got more.
Oh. All right.
Yeah, I'm a lawyer.
Oh,
Remember?
you're extremely articulate. I appreciate it.
All right, well, that's how we use those criminal guidelines in our license application process or our license application review process, and then also for the criminal history evaluation letters. And as I said before, the people can ask for them on their own without having to go to school. Or anybody who just wants to apply for a license and just wonders on their own, well, I wonder if I'll be eligible or not. They can look at those because they're on our website. The law requires us to develop these guidelines and to publish them in the Texas Register. Most normal people who aren't involved in law or government have a life, and they don't read the Texas Register. So we make these things available to the public on our website, and they can look at them there. And so they don't have to get a criminal history evaluation letter. They can get a pretty good idea, but if they've got any doubts about it, we certainly invite them to get that criminal history evaluation. So that's how the public gets to use those guidelines as well. Let me give you just a little bit of background on how these proposed guidelines were developed. It was back on March the 2nd, if my memory is right. Actually, I looked it up on a calendar. It was back on March the 2nd that a work group consisting of members of the advisory board, and excuse me if I don't exactly remember each one of you who was on that work group, but we certainly appreciate your participation in that because you provided us with some valuable insight, your skills, your abilities, your knowledge, your experiences. This was all very helpful to give us insight in how these things should go. In that work group, we fashioned or we crafted these guidelines. We kind of started out with something from some of the other health professions that seemed like they might be kind of similar in circumstances, not in the actual substantive procedures and everything, but similar in circumstances. And we kind of started there, and we built on that. And during that work group, we had a lot of good discussion, and I think we came up with some pretty good guidelines, and those are the ones that we're considering here today, the proposed guidelines we're considering today. And so with that, let's take a look at these guidelines. And I understand you have copies in your materials, but Chris, the smart guy, is going to also put them on the smart board. The first thing I want to point out to you is that these are listed in categories. They're not individual specific crimes, and there's a reason for that. Because, we have, 254 counties in the state and way a lot more cities. We've got 50 states, and we've even got some places that are certainly unusual to me, like American Samoa and Washington, D.C. And they've got their own court systems. And everybody's court system has something, we'll call the same offense something different. It might be larceny in one state, it might be petty in another state, petty theft in another state, it might be misappropriation in yet another. So we try to categorize the crimes so that we don't have to take the risk of having something slip through the cracks and we miss it and say, oh, well, you got away with that one because we didn't know the name at that time. This first one here, we'll give you an example of that. It's crimes against the person, such as homicide, kidnapping, and assault. Now, those three things there, they aren't the only ones. Those are just examples. That's not the exclusive list of crimes against persons. You also see the reasons for each category of crimes and why those reasons, or the reason why these crimes are related to your profession. In the first category here, the guidelines explain that massage therapy licensees interact with clients and the people who might be with them, the caregivers and companions and so forth. And they're going to be in close proximity with people, certainly with the clients themselves. And as with any service, the potential for conflict exists, and it might be a conflict in billing, it might be a conflict in quality of care or effectiveness of the care, personality conflict, who knows? But the potential for conflict exists there the same as it does in a doctor's office or a tire store or anywhere else. People with a history of violent behavior might react violently to that conflict. And so we will try to be very careful. We want to try to be very careful about allowing those kind of people into the profession, because we don't want anybody to get hurt. And I know that you folks don't either. And again, if you have any questions on any of these, please stop me and we'll talk about them. The next one is the category of crimes involving prohibited sexual conduct. Now, those first three reasons that are listed under this heading, that refers to those massage therapy statutes that we discussed earlier, those very specific ones that said a license must be revoked under certain circumstances, or a person is ineligible for a license under certain circumstances. It's right there for the public to see. Everybody should know it, that's the law, and we're going to have to enforce it. We don't have any choice. Also, as with that previous category, licensees are going to be in close proximity to the clients, to people who are accompanying them, and in some cases, as in cases we've worked already, we've seen where they're in massage therapy rooms alone with a client, and a client in a particularly vulnerable position in many instances. And so anyone with this kind of predisposition to commit sexually prohibited acts would have an opportunity to repeat those acts. And speaking of clients being vulnerable, the next category, the crimes involving children, the elderly, or the disabled as victims, this next category is what seeks to protect them, because they are, or at least in most cases, the most vulnerable in our society. So we try to guard against persons who have a history of exploiting or preying on people in this category. Then we have the crimes against property, such as theft or burglary. Not only will licensees be in close proximity to their clients, but also from time to time in close proximity to their property. They may have purses or wallets or briefcases or any number of things in them with a massage therapy room, or for those massage therapists who go to clients' homes. There's all kinds of personal property that may be there. So if a person has a predisposition or a history of committing crimes against property, such as theft, we don't want that license to put them in a position where they would have the opportunity, they have the access to other people's property and the opportunity to steal that property, if that's the way they're so disposed. All right, and then moving along to the next one, along the similar lines, people who have a history of committing fraud or some type of deceptive trade practices would not only have an opportunity to commit similar types of crimes against clients, but also insurance companies and other third-party payers like the government. There's government benefit programs that they get defrauded all the time, unfortunately. Licensees may be involved in billing. They may be involved in filing claims and so forth. So it's very important that we exclude people we cannot trust to perform these functions honestly. All right, let's look at the next two categories, which involve possession or distribution of illegal drugs, and then the next one being the under the influence of drugs or alcohol. And this may sound kind of patronizing, but I would begin by asking you, if you're at a massage therapy establishment and somebody offers the option of an alternative or supplemental treatment, how would you feel about that? You know, it's guaranteed to work. It'll make you feel a lot better than you already feel now. Or if this is not working, what I got will. There are people who would go for that. Now, you folks are a little more astute, you know, obviously, because you wouldn't be here on the board if you weren't. But there are people who are more vulnerable, who are more gullible or more susceptible to fall and prey for that kind of thing. And somebody who has a history of illegal drug or substance distribution, sales, This would provide them with an opportunity to develop a customer base that they wouldn't ordinarily or otherwise have. So we want to be careful about that. Now also, in that other category, a licensee who may be under the influence of alcohol or drugs or some other substance is probably not going to be the best person to provide effective medical care. And it's not somebody I would want working on me, and I don't think anybody here would want that either. So the proposed guidelines include those crimes that involve the illegal possession or distribution or delivery of drugs or illegal substances, and also being under the influence of alcohol, drugs, or some other dangerous substance. All right, this last category then, that involves another statute that's specific to massage therapy. And we already discussed how a person is ineligible for a license if the person is convicted of or placed on deferred adjudication for human trafficking or public indecency, prostitution, sexual offenses, those kind of things. Well, this provision or this subsection, it makes a person ineligible for a license if the person is convicted of a violation of the massage therapy statutes. That ineligibility lasts for 5 years. Now, there was some discussion about that. I think Nick was talking about that as a possibility that for a law change later on. And that may happen, and if that happens, then this of course, would change too. But for now, it is the law, and so we keep it in here to let people know that it is the law and that, hey, we don't have any choice. We've got to enforce it. But notice also that this is for a person, this is very specific. This is for a person who is convicted of a violation of the massage therapy statutes. It's not for a person who was given deferred adjudication. It's not for a person who was arrested and he was released, the charges were dismissed or something like that. This person actually has to be convicted, a final conviction. So it's a little bit higher standard. And I would hope, I don't know, you folks would probably know better than I do, but I would hope that if a law enforcement agency is going to go to the trouble of obtaining a conviction against somebody for a violation of the massage therapy statutes, it's going to be something serious. And so it probably would be appropriate, at least at this time. We'll see what the legislature comes up with on that. But that one exists, like I said, for 5 years. It's not a permanent bar or permanent prohibition like the other one is. Well, those are the crimes that the work group identified as being directly related to the occupation of massage therapy, to include those convictions that require the revocations or render a person ineligible for a license. And they also list, as we noted, the reasons why these are directly related to the occupation and why the Commission should be particularly concerned about persons who are convicted of these crimes. Any questions on any of these?
Questions?
Yes, Russell Rusk, one question. Now, on the crimes involving being under the influence of alcohol, drugs, or dangerous substances, is that something that's going to date back? Because, you know, as young people tend to experiment with things, maybe get in trouble. Is that going to, you know, prohibit them from being licensed? If they've, you know, I mean, I don't know what the situation may be. I was just curious because there are a lot of people that have had substances problems in their past that, you know, may not have it today or, you know, went to therapy or rehabilitation. I don't know, is that saying that they would not be eligible at all to get a license?
No, sir. One of the most gratifying things that I see when I review license applications is when somebody has a history of substance abuse problems, and maybe they've even gone to one of the treatment facilities in the state prison system, intermediate sanction facilities or the Safe P program or one of those. When they submit certificates, when they submit letters from counselors or from others who say, you know, I knew this guy back then, and man, he was a mess. And ever since he's gone through these things, he's been great. You know, he's been terrific. He's been sober and all those kind of things. When you see that kind of commitment to sobriety to somebody who wants to do good, wants to do well, that's very gratifying. And then especially over a longer period of time. That one where you saw the person, or the example I used earlier about the person who 15 years ago was arrested for or convicted for a minor marijuana possession charge, small amount, you know, maybe a college party, who knows. And then nothing since then. Perfect record since then. No, that's not going to disqualify the person. You got somebody who had a DWI 10 years ago, 5 years ago maybe, and nothing else. No, probably not going to
Okay.
disqualify a person. That's where we look at all those factors, and I briefly mentioned those things, like what is a person's overall criminal record. We look at the total picture. How many crimes does a person have? What kind of crimes were they? How long ago since the last crime was committed, and so forth. And then we make the determination based on all those things.
Okay, well, personally, I work with a group of youths that have gone through substance abuse, and occupations such as air conditioner repair, these things, they're not going to be college material for most of them, and not necessarily massage, but there's other occupations. And I was just, people get a second chance, especially with the youth. Okay, so.
They do, and we make sure that under the right circumstances. Now, I will tell you, if somebody's got a 15-year history of chronic alcoholism and half a dozen DWIs, and the last one they went to prison, and they got out a year later, and the day they got out they applied for the license, and they want to be a tow truck driver, we're going to be a little bit leery about that.
Okay.
Just a little.
But that's the extreme example.
Sure.
But you get the idea.
Thank you, sir.
Certainly.
Anything else? All right.
All right, well, I want to thank you for your attention to this information,
Thank you.
especially having to listen to me. I know that's not pleasant. But thank you for your consideration of these proposed guidelines as well. And we hope, and this is what we ask for you to do, is to take a vote on this that will recommend adoption of these guidelines to the commission.
Okay.
I'd like to make a,
Okay. So, is there any discussion before we take a vote on the substance of these things here? Any discussion?
Russell Rust, I'd like to make a motion to accept these.
I second
Good. Second.
Paul Stone, I second.
And is it, everybody say aye, or raise your hand if you're in favor of this, just to make sure it's.
Aye.
Aye.
It's unanimous then. Anyone opposed? No. All right. It's carried, and thank you very much for your hard work and for your clarity of explanation. I appreciate it. All right. I'm assuming we'll just go straight through without a break? Okay. So, we now move on to work group reports. Number one would be standard of care work group. My understanding is, may I say, that they didn't meet, wasn't time for that to happen, so there's no report from the standard of care work group. However, it'd be good to have a report from the licensing work group.
Good afternoon again. And I am Tanya Guthrow, the Director of Field Inspections. And so the licensing work group also somehow or the other covers inspections. So just a clear point of clarification there. And with me, I have Julianne Crocker. She's the lead facilitator for our division, and that means she really crunches the numbers for us. She does a lot of data analysis and acts as my backup often. So I wanted to make sure you got a chance to meet her in case she is the one presenting for our division in the future at any time. So yeah, we want to say thank you to the Licensing and Inspection Advisory Board Work Group for meeting with us to develop the reference guide. We were able to meet 2 times. We met on March the 6th to review the massage establishment reference guide. And what that means is we have a list of potential violations or things that inspectors need to inspect. It includes the actual facility, it includes the license status, it also includes record keeping and things like that. And what we have is each of our inspectors can reference this list while they're out performing massage establishment inspections to ensure that they are providing a standard inspection across the board. So we met on March the 6th. We went over each and every item. We deleted some items that we had included initially after having a conversation with the work group and getting, a better understanding of what we might expect while we were out in the field. We also had several questions that we needed to follow up on. We also met on July the 12th to review the massage school reference guide. It's the same kind of process. We came with a list of the potential things that we needed to check on and make sure that we were performing a standard inspection. And we were able to ask a lot of really good questions, get some good input, and we are now, we have already started to use the massage establishment reference guide. We're live. We're out there doing those inspections. We talked about how we did 29 of them last month. You'll see that on your next report. And we are going to be starting to use the massage school reference guide and start doing live inspections, not just mock inspections. And after we try it out, both of these different documents for a while, we're going to talk to our inspectors. We're going to bring it back to this advisory work group to follow up on any questions, maybe make some adjustments. It's kind of a living document, and sometimes we don't know what we may see when we're actually there on site. And we identified about 5 items during our meetings that the work group wanted to potentially present to the advisory board, and we may continue to discuss these items and then be able to discuss them with the entire board at your next meeting. But I'm going to go over those 5 items right now. The first one was a question regarding the Rule 117.90G, which requires the licensee to obtain written consent of a parent or guardian to provide massage therapy services to a person under the age of 17. And the point of discussion here was, should we change that to 18 years of age instead of keeping it at 17? And again, this isn't for discussion now. I've been working with our general counsel. But I did want to share with you some of those, some of these things that the group was able to identify as like, well, why are we doing it this way? The second item is 117.90R. A licensee shall keep his or her licensure file updated by notifying the department in writing of changes of names, addresses, telephone number, and employment. And the point of discussion here is, should we set a time limit that they need to make these updates to TDLR within 30 days instead of having it just open-ended? And that's helpful for an inspector who may be going out there and realize that there has been some sort of change, but maybe it just happened a week ago, and is that really enough time? So setting a guideline is helpful for inspectors, but that can be discussed later. Next we have 117.83G. Furniture, equipment, and other fixtures shall be of a washable material and kept clean and in good repair. And the question here was about the term washable. Should that be replaced with the term non-porous? And this was probably something that we brought to the table because of our experience working with cosmetology. And that technically you could wash a padded chair, but really you want it, you want these items to be such that they can be easily wiped down. Another point here was not only to change washable to non-porous, but to add the comment where services are rendered, so that in your waiting room you could still have a nice, comfortable padded couch and chair, but where you're actually doing things, you want it to be the type of material that can be easily cleaned up. Next item, 117.83K, oil must be kept in closed containers, and the discussion here was to add the term lubricants. So it would say oil and lubricants must be kept in closed containers. And finally, there was a discussion regarding the change to, this would be a change to the law, so it's not something we could do just on our own, but it's 455.155C2 2B. And the rule is 11784A2B. Fail to provide the massage therapist's full legal name or license number in each advertisement and each time the business name or assumed name appears in writing. The discussion here was deleting the requirement for the full legal name. And so those were the items that we sort of had left over that we felt like might require further discussion by the advisory board, and these potentially could be discussed at the next advisory board meeting. Let's see, I wanted to let you know, yes, we're good to go on both of our reference guys. We're performing live inspections. By the end of this month, we'll be doing live school inspections, but we're already doing those massage establishment inspections. And I just want to say thank you to everybody for your participation and your help. It was very enlightening.
Great.
Okay.
Thank you very much for
Thank
your
you.
work. Okay. Now we're to item H, recommendations for agenda items for next board meeting. Do we have any recommendations from TDLR or from the advisory board?
Colleen, Trent, we can always, we're sure we'll have work group reports again. As we can see from Tanya's group, there's definitely some work that they'll bring to the advisory board, but
Right.
if we need to, we can add as we go. So that's really the only thing I can think of.
Okay. All right. So the next thing would be to discuss the next date for the next meeting, if we can get out our calendars.
Mr. Chairman, Nick Bowinas here. We've got a couple of dates for you in October. October 9th, October 16th. Those are both Tuesdays. If you'd like to continue meeting at 1 o'clock, we could do that.
I would prefer the 16th if possible.
So would I.
16th.
Anyone else have a problem with the 16th? It works for me too. We're good with that?
Unless you are bringing me birthday cake, and then I'll come on the 9th.
Ah.
We don't want to do that to you.
Oh, my God. Happy birthday to you. Yeah. All right, so let's say 1 o'clock then on Tuesday, October 16th.
Got it. Thank you, sir.
Yeah, thank you. Thank you, Nick. So, is there a motion for us to adjourn the meeting at this time?
I'd like to make a motion, Russell Russ, to adjourn the meeting.
Caroline
Tony
Guerin,
Gross, you second.
that.
All right, sounds like we have a second and a third. Thank you all for attending. All in favor?
Aye.
Anyone opposed? No. Thank you all for attending, all your reports. TDLR staff, thanks so much. Meeting is adjourned.